In this bulletin, the US government weighs in on the future of patent rights on printer cartridges in the United States. Hello, I'm David Gibbons and here is the news. The US legal system has just delivered its own briefing about the future of patent rights on printer cartridges to the full bench of the Federal Circuit set to meet in October. The Solicitor General's office filed the brief on behalf of the federal government, which has jurisdiction over government departments and agencies, including the International Trade Commission. Their brief calls for the current Mallinckrodt laws to be overruled, which affects the prebate restrictions or shrink-wrap licensing that prevents consumers from remanufacturing their printer cartridges. The brief also supports overruling the jazz photo laws that currently prevent printer cartridges first sold outside of the US to be shipped into the US for remanufacture. However, the brief also permits US patentees to reserve their US patent rights, a loophole that, as one observer said today, is big enough to sail a container ship through. The patent attorney representing Impression Products in the case with Lexmark International joins me online. Greetings, Ed O'Connor. Tell us more, Ed. Let's start with some basics. Which government departments and agencies does this government brief actually represent?
Well, they included a list of a number of government agencies. It's not exclusive by any means, but included in the government agencies are the Commerce Department, the Patent and Trademark Office, the Antitrust Division, the International Trade Commission, the State Department, the Treasury Department, and the Office of the U.S. Trade Representative, quote, among others, close quote. So it's a wide variety of government agencies that are involved in trade and commerce.
So, Ed, is this particular government brief helpful or harmful to overturning current patent laws?
It's primarily helpful, but with some reservations. And I'll explain that. First of all, there were two distinct cases that are subject to review right now. The one case is called Mallinckrodt, and that relates to the prebate program, which has to do with whether or not a company in the United States, a patentee, can restrict the use of a product by a person who purchases it. And Mallinckrodt case by the Federal Circuit says that essentially, yes, you can put restrictions, including label licenses, on products that have been sold. The government's position on this is that that case is completely wrong. They are in agreement with us that that case should be reversed in its entirety, that it's basically incorrectly decided. Okay. And that once a product is sold, and incidentally, this is the general rule, you buy a patentee, the patentee loses all patent rights. You can't sue somebody who buys a product that I sold you. I can't restrict what you can do with it and then sue you for patent infringement if I don't like your use. So that's the law right now, is those agreements are valid. The Justice Department agrees with me, and also the court in the case, the court below, that that's bad law and should be overturned completely.
So what about the other law in question, the jazz photo law, which you are also wanting to see overturned at the same time?
Well, the government came down with what I consider a rather strange compromise. In the first place, they agree that jazz photo should be overturned. So we're in agreement there. But they also said that jazz photo should be modified to allow a patentee who sells a product overseas to restrict the sale or use of that product in the United States by contract. In other words, if a company sells a U.S. company with a U.S. patent, doesn't have to be a U.S. company, but a company that has a U.S. patent on a product, sells that product overseas, then all patent rights, according to the government, should be extinguished unless the person who sold it has a contract arrangement, a specific contract, with the purchaser that says the purchaser cannot bring that product, or no one can bring that product back in the United States without being subject to patent laws. In other words, a specific contract as an exception to the general rule. So the government's position is that parties should be able to make those contracts But absent such a contract, that Jazz Photo should be overturned to the extent that it says first sale extinguishment doesn't apply to overseas sales. So for products that have been shipped into the United States and some seized by the customs pursuant to an ITC order, probably none of those products today have any kind of an exceptions contract, which means that all of those seizures or any further activity by the ITC should be halted regarding any importation of spent or used products.
So what's next? Sorry.
Let me finish. That's according to the government now. Now, it's not the decision of the court. That's just the government's position. So go ahead. You had another question. You were asking what's next.
Yeah, thanks for making that point. So yes, my question is, what's next? The amicus briefs have been filed to support your argument. What about on the other side with Lexmark International and the amicus briefs they will be expecting to support their argument? And when will the hearings all take place?
The hearing is set for October 2nd, and in the last interview you said it was October 3rd because I had given you this information. It's October 2nd. The Lexmark brief, I'm not sure when the exact date is that it's due, but it's due in a little more than a month. And then their amicus briefs are due a week later. So probably, this is June, so probably by the end of June, early July, I believe, that they would have their brief would be due, and then about a week later. So probably by mid-July or latest early August, that will be the end of the briefing. And then I have an opportunity to do a reply brief, and I don't remember exactly how long I have, but I have a chance to respond to these arguments. I would probably take issue with the government's position with regard to the rights of people to contract to preserve U.S. patent rights. I think that's a bad position, and it could be very bad for business. So, but we'll have to see, and I'm conferring with some of the amici lawyers in terms of formulating our strategy, which has not yet been developed.
Ed O'Connor, thank you for joining me today.
Well, you're very welcome.
And for more breaking imaging news, go to irecyclingtimes.com or grab a copy of Recycling Times magazine, published in 5 languages every month. This month, Ms. London Thompson, one of the team at LMI Solutions, is on the front cover, and it's all about remanufactured printers. A great story. Thanks for watching. See you again soon. I'm David Gibbons.